We shall commence this module by studying about the Securities and Exchange Board of India Act 1992. The Securities and Exchange Board of India was officially established in the year 1988 by Government of India when it succeeded the Controller of Capital Issues 1947, which was the only regulatory body operating then. The Parliament granted Security Exchange Board of India its statutory powers in 1992 through provisions of the Securities and Exchange Board of India Act 1992. It was formed on the premise of protecting interests of investors in securities and to promote development and regulation of the securities market. According to provisions of this Act, the board is a body corporate having perpetual succession, a common seal, with power subject to provisions of this Act to acquire, hold and dispose of property both movable and immovable, and to contract and shall be said name, sue or to be sued. Security Exchange Board of India has its headquarters located in Mumbai and its 4 regional offices are based in New Delhi, Chennai, Kolkata and Ahmedabad. SEBI has come up with a number of initiatives and they are aimed at regulating and developing the securities market in India and to improve its safety and efficiency, all of which have made an impact on various aspects of our economy. These initiatives have transformed our securities market in terms of market capitalization, number of companies listed on the stock exchanges and trading volume in spot and future market. SEBI was formed to cater to the needs of 3 types of groups operating in the market. They are issuers of finance. They involve large joint stock companies in need of long-term funds depend heavily on the securities market. They require funds to meet their financial requirements. The SEBI serves them by providing a safe market from where they are in a position to raise sufficient and timely finance. Second group is investors. The suppliers of finance include the savers of money who rely heavily on capital market. SEBI ensures that their funds shall be parked in authentic and protected corporate destinations. The third group is intermediaries. The intermediaries include various types of brokers, issue houses, etc., which acts as bridge between issuers and providers, that is investors of finance. SEBI ensures the corporates and investors a competitive, professional and fair market to trade in. After studying this module, we shall be able to understand the meaning of Securities and Exchange Board of India Act 1992. Then we will also learn about the establishment of Securities and Exchange Board of India Act as per SEBI Act 1992. Then we will identify the composition of the board and its powers. And then we will conceptualize the objectives of SEBI. Now we are starting with the organization and power of the board. First of all, we will explain the organization of the board. As per section 4 of the SEBI Act 1992, board of SEBI comprises of the following. First, chairman, who is formally appointed by the central government. 2 officials of central government from Ministry of Finance and Ministry of Corporate Affairs. Thirdly, 1 official nominated by the RBI. Fourthly, 5 other members nominated by the central government, out of whom at least 3 shall be working as a whole-time members. The other important features of the board are the chairman and other members consisting the board, that is A and B, should be people of high integrity, ability and standing. They are expected to have sound knowledge and experience in areas relating to finance, law, economics, accountancy and administration, so that they are in position to take rational decisions for functioning of the SEBI. Also, they must possess some experience in dealing with the problems relating to securities market or any other thing which may be found useful by the board. The chairman and members referred to in A and D categories are appointed by the central government. Members referred to B and C are appointed by the central government and RBI respectively. The board of members manages, supervise and direct the affairs of the board and has all the powers to do things and acts which may be exercised or done by the board. The chairman also has powers of general supervision and directing the board and also has power to exercise and do all acts and things which are within the sphere of influence of the board. Now we are going to discuss the power of the board. Section 11 of SEBI Act provides for the functions and powers of the board. Some of the powers of SEBI are enlisted as under. First, the main function of the board is to protect the interest of the investors in the securities market and to make provisions for its development and to regulate malpractices prevalent, if any, taking by measures which it may feel fit for the purpose. Secondly, in order to empower SEBI to sustain its regulatory function efficiently, it has the power to approve the bylaws of the stock exchanges. It has the power to instruct the stock exchanges to amend their bylaws if required. It has also power to supervise and go into the details of the accounts of the stock exchange etc. periodically, and they can also ask for returns from the stock exchanges. They can inspect the books of accounts of various intermediaries involved in securities market so as to ensure their proper conduct. They can compel certain companies to get their shares listed in one or more stock exchange. The SEBI board can ensure compulsory registration of brokers and other intermediaries involved in stock exchanges. They can also formulate any laws which it feels necessary for smooth and fair conduct of the securities market. Further, the board has same powers as that of vested in the civil code. Under the Code of Civil Procedure, while trying a suit in respect to recovering and producing books of account and other documents for inspection, summoning and enforcing attendance of persons and examining them on oath. The board also has power to give and to take any measures that to be recorded in writing to protect the interest of the investors in the securities market. They can suspend of trading of any security on a recognized stock exchange. They can restrain any person from accessing the securities market and prohibiting any person associated with the securities market from buying, selling or dealing in the securities. The board has the power to give directions to any person associated with the securities market or any company in matters related to protection of interest of investors. They can develop the market's policies and procedures for the smooth functioning of securities market. They can help in preventing the affairs of any entity which are detrimental to the interest of the market. They can help in securing proper management of any such intermediary or entity etc. Now we are going to discuss the procedure of termination of service of chairman or any other member of the board. Section 5 of the Act deals with the termination of services of the chairman and other members. In this, we have that the term of office of chairman and other members may be as prescribed. The central government has the right to terminate the services of any member or chairman of the board before expiry of complete term if It feels just by giving a written notice of at least 3 months or 3 months' salary and allowances in lieu of such removal. Also, the chairman and any other member of the board have full right to vacate or relinquish their position before expiry of their term, provided they give notice of at least 3 months in writing about the same. Then we have the procedure of removal of member from the office. According to the provision of section 6 of the Act, the central government has the power to remove any member from office on the following grounds. The member is at present or at any time has been adjudicated insolvent. The member is of unsound mind and has been declared so by a competent court. The member has been convicted of an offence which in the opinion of the central government involves a moral turpitude. The member, in the opinion of the central government, has abused his position so as to render his continuation in office detrimental to the public interest. However, the Act provides that no member shall be removed under this clause if the member has not been given reasonable opportunity of being heard as regards the matter referred above. Now we are going to discuss about the meeting of the board. Section 7 deals with the meeting of the board. It provides that the board shall meet for proceedings as regard transactions of business at its meeting at times and places as prescribed by the Act, and that the full procedure for conduct of such meeting be followed. If for any reason the chairman is unable to attend any meeting of the board, the meeting shall be presided over by any other member who has been chosen by members present at the meeting from among themselves. In the following circumstances, the board meetings can be invalidated. This is discussed under Section 8 of the Act. Section 8 of the Act provides that the proceeding of the board can't be invalidated merely due to the following reasons as mentioned below. First, if there is any vacancy in the board or any defect in constitution of the board. Secondly, there is any defect in appointment of a person acting as member of the board. Thirdly, if there is any irregularity in the procedure of the board which do not affect the merit of the case under discussion. Now we are going to discuss the objectives of Security Exchange Board of India. We are starting with the basic philosophy behind the establishment of SEBI. According to SEBI Act 1992, SEBI has been described as body corporate which is based on threefold principles of: first, ensuring transparency and fairness in functioning of the regulatory mechanism; secondly, enforce a mechanism which places due respect and recognition to the fundamental rights granted under Constitution of India and other principles of natural justice; thirdly, to enforce control of judiciary in the administrative section. The three functions of SEBI, that is quasi-judicial, quasi-legislative and quasi-executive, have been rolled as one. In its legislative capacity, SEBI drafts rules and regulation, conducts investigation of matters pertinent to securities market and executes them as a part of its executive function. As its judicial function, it passes rulings and orders. All this has made SEBI a powerful entity. However, there is an appeal process so as to make it more accountable for its actions. There is a 3-member tribunal known as Securities Appellate Tribunal, and the second appeal lies directly to the Supreme Court. Then we have objectives of SEBI. The 1980s witnessed a tremendous growth in Indian capital market due to increased public participation, which also brought with itself numerous malpractices on account of brokers, merchant bankers, etc. They duped the investors of their funds. These fraudulent practices corroded the confidence of the investors as their grievances could not be redressed adequately by the government and the stock exchanges working then. As a consequence, the government established the SEBI as a separate regulatory body which could protect, preserve and promote the integrity of the securities market so as to bring back investors' faith in the market and bring it at par with the other contemporary securities market of the world. Its main objectives are: first, regulation of stock exchanges. The very first objective of SEBI is to ensure proper regulation of stock exchange so that all the parties, brokers, merchant bankers, intermediaries, etc., they are operating in it are provided efficient services. Its main aim is to ensure fair trade practices and promote professionalism. The second objective is protection of investors. Investors are the most important channels in securities market because they are the providers of finance. They form the foundation of market, so their protection becomes imperative. For this, SEBI ensures that investors are provided with accurate and timely information to rest their financial decisions on and aims at curbing malpractices associated with the market. It makes provisions so as to reduce the risk and delay involved in the delivery of shares and payment. The third objective of SEBI is to control over intermediaries. Intermediaries are the linking pin between the issuers and the providers of finance. They play a crucial role in the market by mobilizing funds from one channel to the other one. Thus, it is very important to keep a close track of their functioning so that none of the parties involved in the market is benefited at the stake of the other. The next objective of SEBI is of consumer education. SEBI educates and guides the investors about various ways and means of investment, procedures, schemes and malpractices prevalent in the industry so that they park their funds with full caution. The next objective of the SEBI is to regulate the market. SEBI aims to curb the malpractices associated with the securities market such as insider trading, price rigging, etc. and it frames various provisions to ensure smooth and fair functioning of the securities market. These provisions are monitored and amended from time to time to achieve a balance between corporate statutory regulations and corporate self-regulation. Now we are going to discuss the functions of SEBI. Preamble of Security Exchange Board of India describes the functions of SEBI as to protect the interest of investors in securities and to promote development of and to regulate the securities market and for matters connected therewith or incidental thereto. To fulfill its objectives of securing a fair and equitable market, the functions of SEBI can be categorized as: first, developmental functions. The main reason for establishing of SEBI is to develop the securities market in India so as to bring it at par with global cult markets. To perform the role of a developer of the market, SEBI tries to promote and develop business in the stock market by adopting a flexible approach for which it has been permitted, and it takes actions like internet trading through registered brokers and has made underwriting optional to reduce the cost of issue. Secondly, under the developmental functions, the SEBI tries to promote and undertake regular training of the intermediaries operating in the market such as brokers, which ensures smooth, safe and speedy transactions. Apart from the development functions, it has protective functions. SEBI acts as a preserver of the securities market and performs the following functions to protect the interest of its stakeholders. As a protector of the market, the SEBI checks malpractices prevalent in the market such as price rigging, insider trading, and prohibits fraudulent practices by preventing companies from making misleading statements. Secondly, it undertakes steps to educate the consumers about ways and means of functioning of the market so that they may be able to take a rational investment decision. Thirdly, it promotes fair practices and ensures adoption of a code of conduct through issuing guidelines to be followed by all. For example, to protect interest of debenture holders, it has issued guidelines which prevent companies from making any changes in terms of issue mid-term. Next, SEBI has been granted authority to penalize the parties indulged in unfair practices, and they can impose strict fines on them along with imprisonment. For example, it has been empowered to investigate cases of insider trading and has provision for strict imprisonment. Apart from the developmental function and protective function, it has certain regulatory functions also. To regulate the business in stock market, SEBI performs following functions. First, it frames rules and codes of conduct to be followed by intermediaries of the market such as the merchant bankers. Secondly, it registers and regulates the functioning of the stockbrokers, trustees, merchant bankers, and all other parties associated with the market. Thirdly, it regulates mutual fund and takeover bids by companies. Fourthly, SEBI conducts periodical inspection and audit of companies. In light of all the above mentioned functions, SEBI aptly has modeled the role of a watchdog over the functioning of the stock exchanges and the stock market. Since its inception, SEBI has been functioning with full zeal and vigor to achieve its objectives of protection, preservation, and promotion of interest of all the parties involved in the securities market. SEBI has always been successful in doing so, as risk of default etc. have reduced considerably due to various advancements as capitalization requirements, margining, establishment of clearing houses, etc. Now we are going to make a summary of what we have discussed so far. We have started this module by making a definition of the SEBI Act and SEBI. SEBI was established by the Government of India as a statutory body according to the provisions of the SEBI Act 1992, which has a separate legal entity and perpetual succession. Then we have discussed the basic premise of establishment of SEBI was to regulate and control the functioning of the securities market to ensure a fair and efficient trading mechanism. Then we have discussed the three main areas of focus of SEBI, that is, the investors, issuers, and the intermediaries. The headquarters of SEBI is located in Mumbai, and its 4 regional branches are all over in India. The organization of SEBI comprises of a chairman nominated by the central government, who presides over a board of members drawn from areas of finance, economics, and general administration. The board has the special powers to ensure orderly and just conduct of financial transactions in the market. It can prevent any malpractices associated with the same. The SEBI has brought back lost investors' confidence in the securities market by enacting and amending various laws for their protection, thereby bringing our capital market at par with other developed securities market of the world. The main objective of formation of SEBI is to protect the interest of investors in the market so as to ensure smooth and timely availability of finance. SEBI aims at securing professionalism, among intermediaries so that market efficiency is ensured. There have been recent amendments in SEBI Act 9 2013 to further catalyze the role played by this in the growth of the economy.